Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button for me, please. There's a PayPal link down below for anybody who wants to share some love. Every little bit is appreciated. And the StreamYard link is there for anybody that wants to join the panel. How you doing tonight, John?
Doing good.
Good,
All is,
good.
all is quiet now. 3 nights in a motel, so it's
Ah,
just tough to find a quiet place.
I hear you. I hear you. So if you remember the other day, we were talking about, what was it, real party and interest and some other things. I can't remember exactly which video it was on, but we ended up talking about champerty and maintenance. And so while I was researching that, I came across something that I wanted to show everybody tonight. And it's called the inauthentic claim. And through this inauthentic claim and doing the research on this, I found out and realized this is the perfect thing to use in regards to what I've been talking about. Not a United States citizen, not a resident. It's an inauthentic claim. Why? John, do you know why it's an inauthentic claim?
What was the subject though? What's
It's an inauthentic claim to be a resident for most people, and an inauthentic claim entirely to be a United States citizen.
Well, Keith, because it's a taxable corporation. I'm a human being.
Well, that, and as well as certain codes that they have that create the obvious exceptions. And that's because they're specifically defined. And so when we find out that in order to be a United States citizen, you got to be born in the United States. Show me where anybody has ever been born in the United States. They have a particular problem in that because there isn't. There's no birth registration in the United States. So they can't prove that. The only thing they can prove is that somebody was born in a state organized under the laws of the United States, but they were never born in the United States. So there is no United States citizen except for a United States business. And being born in one of the states as a resident, you're deemed for income tax purposes at the state level, and at the federal level, a federal, state, or municipal officer or agent whose that resident presence is deemed necessary.
Yeah.
Neither of those is true, so there's an absolute exception.
Yeah, and before 1900, they didn't even have us born in the States, Keith.
Exactly.
I mean, right, there were no birth certificates. So.
Absolutely. They don't have any proof of a born or birth. Either one. It doesn't matter. So we're going to take a look at this. This is just a summary. It's an abstract. They call it an abstract. And it says, this article argues that third parties, beneficiaries, should be able to invest because they aren't already invested, because they're third parties to the investment of the two people investing, in lawsuits to a much greater degree than is currently permitted in most jurisdictions in the United States. So as that third party, that is the beneficiary, and in both trust law and equity are deemed to be the true owner is the one that holds the primary investment to begin with. So let's flip the tables and show the exception is that you, too, by naming me in any way, are proving that you are investing in me. That's the investment. The laws of assignment and maintenance limit the freedom of litigants to sell all or part of their lawsuits to strangers. See, I'm not a plaintiff, and I'm not a defendant. I'm a litigant. To sell all or part of the lawsuit to strangers. So as a litigant, I can sell a part of the lawsuit to this private attorney to help in the decision making, in the counseling, not in a representation. Then I can go hire an accountant to counsel me on the figures. I can go hire an English major to counsel me on the grammars. See where this goes?
Yeah.
To strangers, not attorneys. Strangers and sojourners with us. I argue in the article that the foundation of both doctrines is based on something I call the theory of the inauthentic claim. The theory of the inauthentic claim asserts that there is a quality, separate and in addition to legal validity, which confers authenticity to a lawsuit. Remember the real party in interest? You can't bring a case unless you're the real party in interest. You can't claim to be plaintiff unless you're real party in interest. Is the state of Iowa a real party to begin with? Or is it the people that are operating under a agreement to carry a license for the licensee, the state? See, the state is the one that's carrying that license. And all those officials have to take an oath of office to be a licensee under that licensee. And remember, they're licensed because they ceded their jurisdiction to who? The United States, the licensor, under the laws of the United States. They're the ones with the contracts. And holding a license shows that you're in contract. An ID shows that you're in contract. Using that name and address the way they've indoctrinated you, it presumes that you're the contract postal unit, running a business out of your principal place of residence.
Right, but it was never done properly in our case, right, Keith? We were never
Correct. It was never qualified.
qualified or even approved by the Board of Governors.
Correct. It holds instead that the mere fact that a third party involved him or herself in the suit for the wrong reasons is proof that the suit is against public policy. For the wrong reasons, but for the right reason, and that is because everything that they deal with is a derivative of myself, and I am the exception. I am the exception. You can't include me in that. Well, what are the exceptions? First and foremost, there was no memorandum stating the exception, and that's what lays open the presumption. This article examines two arguments that might be used to defend the theory of the inauthentic claim, one from history and one from jurisprudence. I conclude that neither argument is persuasive. I conclude the article by sketching a research agenda based on empirical evidence that would help policymakers and judges to choose the socially optimal set of rules for third-party investment in litigation. But again, third party as a third-party beneficiary deemed to be the true owner, and you're investing in the ownership. And I'd never had I known that I was giving up rights, titles, and interests to the name, I'd have never done it. That would be unconscionable. It's time to fix it. Keywords: assignment, maintenance, chamferty, choose an action, non-assignability, and corrective justice. Talking about correcting the record because they weren't supposed to be able to make the assignment to begin with, and my choose an action would be different had I known so, and therefore I am going to maintain the suit myself or champerty the suit myself by being able to sell it off for other people to counsel. Does that make sense? Any questions there?
Nope, no questions. But I would just say, get the information maybe to the Postmaster General. That'll clarify the record right there. It's in the right hands, right?
Well, yeah, that's what I'm assuming as well. It's, they're supposed to be holding the title, I believe. Title for title, indemnification for surety, surety for indemnification, quid pro quo. If they're the ones that are providing the surety for the United States, then they should be the one holding the title that has the indemnification attached to it. And this goes because that indemnification is for the simple fact that they converted somebody that was foreign to something that is domestic. So the next one, I'm going to drop this link down in the chat so everybody can read it, is that document that they're talking about. And it's a 95-page document. I want to read the first part. This article argues that third parties should be able to invest in lawsuits to a much greater degree than is currently permitted in most jurisdictions in the United States. The laws of assignment and maintenance limit the freedom of litigants. So therefore, because it was unassignable and there was an assumed assignment, the Social Security number was assigned to the name of the individual, and the individual's name and number identify a record, and that's what it assigned, was the record. And that's their maintenance, not mine. Okay? I'm Champerty. I get to choose to sell all or part of my lawsuit to strangers so that in that counsel, I can better make my case. I'm not going to represent or present. I'm going to make my case. It's the language, people. Get down to the simple terms. I argue in the article that the foundation of both doctrines is based on something I call theory of inauthentic claim. The theory of inauthentic claim is important because it plays an important role in restraining transactions between litigants and third parties today. Restraining transactions. That's what we're getting caught up in, those transactions. Those aren't our transactions. However, because there's an absolute need for us to, in the usufruct system, to alleviate the cost, expense, and everything of having everybody else put that card in the machine for you or whatever, they give you a card and you have, as holder in due course, the ability to enforce it. How are you going to enforce it? What is your capacity of enforcement? That's what has to be explained in the documentation. That's where the documentation is wrong. They're claiming you don't have enforcement. You have a liability. The law of assignment, while much more liberal than it was at the time of Blackstone, still forbids the assignment of numerous causes of action. States' vital statistics jurisdiction was split up, and now they have all kinds of venues, and they even tell you they do what's called forum shopping to find out what jurisdiction they want to come at you in, and in that, if you beat them in that jurisdiction, they switch to another one. Okay? Those are different. They're switching up causes of action by switching up the jurisdictions. Again, even as a contractor, you have your choose of action. You have your choice of jurisdiction, including suits for personal injury and fraud. The law of maintenance has not been liberalized nearly as much as the law of assignment. Everything you sign is an assignment, as signed. And you did so mentally thinking you knew what you were doing. You had the mentality as signed, and you never qualified the mentality of knowing. You qualified the mentality in blank, saying you didn't know a fucking thing. A signature in blank, a blank signature. And when you think about that, how can a signature be blank if you signed? It's missing an element that's needed. And there is an active debate occurring within the courts and among policymakers today about whether to allow increased investment in litigation. Double unto her, folks. Like I said, you want to bring a measly little $350 bond and play your silly games? Tell you what, I'm going to indemnify everybody, but in order to do that, I got to jack that son of a bitch up to at least $3.5 million. Let's go. I see your $350. I raise you to $3.5 million. You got that? Can you call that bet? Nope. Pay the man. It's a poker game. So let's look at the next one. So in recognizing the foreign element and the fact that you're just sitting at a gambling table and you're using house chips, but you obviously just have a bigger stack than him. So I'm all in. I'm a crazy son of a bitch that learned how to play poker so well, I am all in every fucking hand. Let's get it. I'm not going to play these silly games no more. You want to play poker with a big dog? He's sitting right here with me. Let's play his house chips. It's called truth. So we look at this Foreign Sovereign Immunities Act, a guide for judges. The Federal Judicial Center publication was undertaken in furtherance of the center's statutory mission to develop and conduct education programs for the judicial branch. While the center regards the content as responsible and valuable, it does not reflect policy or recommendations of the board of the Federal Judicial Center. So they're literally, understand, just like any copyright disclaimer, they're saying none of this is worth anything. Okay? If you put value into it, you're the sucker. Quit doing it. Quit believing the bullshit. However, we can get value from it by reading a few things. First basic rule, second basic rule. Let's take a look at those. First, we'll look at the preface to the second edition. It says, in an understatement, to say that the Foreign Sovereign Immunities Act frames a dynamic area of law. In the 5 years since the first edition of this guide was completed, 2018, I believe, or maybe there was a publication time, I think it was 2015, and this was published in 2020. The statute has twice been amended by Congress and has been addressed by the U.S. Supreme Court on 5 separate occasions, by the Court of Appeals in more than 150 decisions, and by the district courts in excess of 500 times. And they're going to start hearing about it a lot more. Consistent with the aim of the original publication, however, this edition notes these developments only where relevant to providing a fundamental understanding of the statute and the main issues it presents. So let me remind everybody, in equity does not allow a statute to be used as a cloak for fraud. So again, 48 CFR 52.212-5, contract terms and conditions required to implement statutes or executive orders - commercial items, commercial goods. This guide does not attempt to compile all relevant decisions or to explore all issues in depth. That's why they look and seek for outward objective views and opinions, and you're free to communicate with these people and let them know your opinion. They seek it. This edition does not or does take into account, however, the publication of restatement of the law fourth, the Foreign Relations Law of the United States, which includes a substantial discussion of the law of foreign sovereign immunity as defined and applied by U.S. courts. The author participated directly as a co-reporter in the preparation of that publication. Relevant sections of this new edition of the restatement are referred to the appropriate points in the discussion. This edition of the guide is current through November 1st, 2018. So, introduction, the guide provides an overview of the Foreign Sovereign Immunities Act of 1976. It is intended as a practical introduction for those who have little knowledge or experience with the statute as interpreted and applied in the U.S. courts. So I urge you to read it. It's one of the most important distinctions to make because it deals with exceptions. The focus is on the basic legal issues faced by U.S. courts in cases arising under the statute. Under the statute, contracts. Case discussions and citations are illustrative rather than exhaustive. In other words, they're looking for remedies. These are equitable, but they don't have all that equity yet. If you want equity, you must first bring equity. And few references are made to law journal articles. You have the right to observe your world and make a private journal. And even if you don't know the law, but you follow the law within your heart, you yourself are a law unto yourself, and you may journal that law. Or other secondary sources. Following this brief introduction, the guide discusses the statute's purpose and scope of application. It reviews the jurisdictional, procedural, and evidentiary issues most likely to arise at the outset of litigation, and it discusses the entities entitled to immunity, in particular the distinctions between a foreign state, its political subdivisions, and its agencies and instrumentalities. My foreign state. I live in this world, but am not of this world. I have no political subdivisions. I am of the I am. Agencies and instrumentalities is this body. It then provides a description of the specific exceptions to immunity as well as the statutory regime applicable to execution of judgments and attachment of assets. So again, that's a military term, and it is a military government, and their judicial shit has to be done, it doesn't say judicial, but their judicial shit has to be done through a requirement, a need of the military, the army, or the United States, not some political subdivision known as the state of, which is a foreign state and an agent and instrumentality of the United States. It then provides a description of the specific exceptions to immunity as well as the statutory regime applicable to the execution of judgments and attachment of assets. That's the 4th and 5th and 6th Amendment. By and through a conversion of the First Amendment. Part 7 discusses the terrorism exception, which has recently been revised again by Congress. So you have to be subject to those codes to supposedly get an exception. See, there's an exception to it because the codes don't apply to begin with. So when you try to use that terrorism shit on me, you have to go to the international code, not your domestic codes. The FSIA governs all litigation in both state and federal courts against foreign states and governments including their agencies and instrumentalities. The FSIA governs all litigation in both state and federal courts against foreign states. That says it's not the United States. Foreign Sovereign Immunity Act governs. The United States doesn't govern. Congress doesn't govern. You understand the language, folks? The FSIA governs, not them. It's already set. It's as set. That's the asset. You just need to know it. It provides the exclusive basis for obtaining jurisdiction over these entities in U.S. courts. It provides the exclusive basis for obtaining, saying that they already don't have jurisdiction, they must obtain it. In order for the court to obtain jurisdiction, the plaintiff must first serve the defendant in the state in which the court sits, as set. And the defendant needs to voluntarily appear in the court, including special rules for service of process. 22 CFR 93.1, and then 93.2. You have to have diplomatic channels of notice for proper service, and you have to, in that notice, be able to give them notice of a suit. You have to have my consent. Just like the United States, you have to have their consent to sue them. You have to have my consent to sue me. It says it everywhere. It's uniform throughout the jurisdictions, and contains a comprehensive set of legal standards governing claims of immunity in every civil action against a foreign state or its political subdivisions, agencies, or instrumentalities. It also prescribes rules regarding enforcement of judgment. Again, it's rules, not laws. Regarding enforcement of judgments against foreign states and related entities. The estate in a matter of equity, so they must recognize the beneficiary as the true owner. Foreign sovereign immunities, it is a global trust. The FSIA recognizes immunity for public acts. That is to say, acts of governmental nature, typically performed by a foreign state, but not for acts of a private nature, even though undertaken by a foreign state. So my intent was undertaking those actions for private nature. I went out and bought that car as a matter of a private nature. Yet it was an undertaking by a foreign estate. That's, again, you see that term undertaken. They know what that term means. You should learn it too. You're undertaking the liabilities of the decedent. You are signing on the instrument and taking upon a liability for the person so named in the instrument because your signature wasn't unambiguous. You left it blank. You have to let them know who you are. So the first basic rule under FSIA, foreign states, and remember, it's a rule, and governments, including their political subdivisions, agencies, and instrumentalities, are immune from suit in both state and federal courts, unless one of the statute-specific exceptions apply. They have to apply an exception in order to be able to bring the suit. That means they have to name the exception. That means they have to show how it specifically applies to me. Why? Because the legal system is an exception to the law. So they have to show why my exception is applied and brings me into the legal system. Thus, because they're only at law. Thus, jurisdiction exists only when one of the exceptions to foreign sovereign immunity applies. If the claim does not fall with one of the enumerated exceptions, the defendant is entitled to immunity and the courts lack both subject matter and personal jurisdiction. They have to prove that the assignment was made and that I am maintaining and have in that maintenance agreement somehow given up champerty, my rights, titles, and interests to the property. They can't do that. Had I known that's what was going on, and being of competent mind and body, sound, I'd have never done that. And I'm telling you, I'm not going to do it now. Forevermore. By Benefactor. Keith. You need any more than that? You need to talk to him. He can tell you thy name. And he's also going to tell you that, yeah, I think he doesn't fear anything. I've redeemed him. He's mine. And I shall not waver. All FSIA cases therefore require courts to address three related questions at the outset. Is the defendant a foreign state or government? Scott versus McNeil. Court of probate has no jurisdiction over the estate of a person who is in fact alive. Therefore, they can only take upon a corporate representation through a suit in an action by the state or a fictional plaintiff, because they're playing a fictional game with a fictional decedent. Within the meaning of the statute. Oops. So even the definition of a foreign state or government within the meaning of a statute is implementing the statute. So again, that foreign state, I am in this world and not of this world. I don't know what kind of state you're talking about here, specifically since it's foreign and state in lowercase. And then, of course, government in lowercase. That's the mentality and how I govern that. Well, it's my free will and I choose to follow his will. And if you'd like to talk to him, he's right here, omnipresent. Has valid service been made as provided by the statute? Again, in order to implement that statute, you have to have a contract for me to receive the service as a receiver. Quit filling out that change of address, suckers. You just filled out a contract with the United States Postal Service to be a receiver of service, and they're the registered agent. They're the trustee. That change of address, you ladies and gentlemen, moms and dads, when you send your children out into this world to be adults, it's the wrong change of address. Form 8822, change of address or responsible party. Does a statutory exception to immunity apply? If it's statutory, again, it's a contract. Therefore, it doesn't apply. And that is why FSIA governs all foreign sovereign immunity. If the answer to the first question is yes, the statute applies. Is the defendant in order for the court to obtain jurisdiction, personal jurisdiction over the defendant, The plaintiff must first serve the defendant in the state in which the court sits, and the defendant needs to appear voluntarily in the court. Ladies and gentlemen, you can seek counsel in an English major, and they will explain that the defendant, as so described here, and of course correlating with the all caps name, is known as a total fiction, an abstract noun. It does not exist. You cannot smell it. You cannot taste it. You cannot touch it. You cannot see it. And you cannot hear it. It can't do a fucking thing. It's all babble, folks. However, even when the answers to the first and second question are yes, the case must be dismissed if no statutory exceptions apply. However, even if when the answers to the first and second questions are yes, the case must be dismissed if no statutory exception applies. See, they're equitable, but they have to accept something that's outside of it, something that's not there. Even in situations where the wrongfulness of the foreign sovereign's conduct is clear and indisputable. So even if you're wrong, sorry, if an exception does apply, the defendant lacks immunity and jurisdiction exists. 94 cases, and they all use statutes against somebody that's not in fact a resident, not in fact a United States citizen, and this is indisputable because it's an inauthentic claim. And again, but the statute continues to govern the proceedings against qualified defendants. Qualified defendants are the ones that qualify their fucking signature and knowingly commit these acts, and then are found to be in violation because they knowingly do so. Reflecting the particular sensitivities of litigation against foreign governmental entities, the FSIA provides these entities with certain protections and benefits. Certain protections and benefits. This sounds like it's ordered. And again, I remind you, this is a trickle-down system where even the U.S. Code shows that protection orders are given full faith and credit. And that's because they recognize the beneficiaries who are supposed to receive the benefits are the true owners. Such as extended time for answering complaints, a right of removal of the case from state court to federal court, federal question for federal removal, or federal removal for federal question of diversity of citizenship, entitlement to a non-jury trial, a bench trial, en banc, limitations in private, limitations on award of punitive damages, and constraints against attachment of and execution against government property. See, all their concern is about their property. They don't want the state coming after government property. Well, what the fuck is a United States citizen but a United States business? Oops. The second basic rule. The statute also provides foreign states and their agencies and instrumentalities with immunity from execution of judgments and prejudgment attachments. Prejudgment attachments. What is the prejudgment attachment, John? Iman? Either one.
Iman's doing good on the chat, so I'm going to let her take that one. Do you see her comments about the foreign sovereign immunities, Keith?
I'm not getting up fresh chat. All I've got is the last one I got was 9:22 p.m. Oh, she's in back chat. I'm sorry. Duh. It's the birth certificate. That's the first attachment. Actually, no, I can't even say that. I have to revert back to the stream we did the other night, Sunday night, where we had Pastor of the Way was with us, and he explained that the first document is actually some kind of paternity document that mom signs about 6 months prior to going to the hospital to give birth. Somewhere along that prenatal care, the doctor has her sign a document that does and that's the first prejudgment, where things are going to be entered into a judicial system by a private journal, converting it to a general journal that then is later attached to the general ledger. Go ahead.
Yeah, where they actually allow her to take home the baby because she donates the placenta. Interesting.
Yep. Donate the placenta. Iman says sovereign immunity refers to the special status that a borrower has if it is a foreign state as defined in the U.S. FSIA. Absolutely. Foreign Sovereign Immunities Act, namely immunity from court jurisdiction and immunity of its property from attachment or execution. Yep. As general principles, a foreign state cannot have its property in the United States seized to pay a judgment. Correct. Property of a foreign state that is used for commercial activity in the United States may be subject to attachment as a provisional remedy. A provisional remedy, and that's the ID. That's driver's license, that licensing. That's the attachment. Property of a foreign state. I'm the foreign state, and I have property of the United States under the laws of the United States, no matter what instrumentality, department, agency, branch, whatever it came from. I'm a foreign state in holder in possession of proprietary information, proprietary product. And that means there's an attachment, okay? And it's a provision that if I get caught with that attachment, I'll be subject to those statutes. Does that make sense? That license is a foreign waiver or foreign sovereign immunity waiver. That's what you're doing. You're waiving foreign sovereign immunity by joining a labor union.
Right. I call it a servant ID.
Yep, it's a labor. You are joining a labor union. The rules governing these issues are in some respects more restrictive than the judicial or jurisdictional rules. So a foreign state or agency or instrumentality may validly be subject to a court's jurisdiction, but its property may nonetheless be insulated from execution of resulting judgment. So this is why we go in and plead guilty and give them a handwritten statement of guilt. This is what they were afraid of 8 years ago when I walked in and tried that. And then they threatened me with arrest. And I asked my companion, hey, go home and get my birth certificate. I was that fucking close. That fucking close. Typical cases. The most common FSIA cases involve claims against foreign governmental entities for breach of commercial contracts for the purchase or sale of goods or services. See, that's that UNCTRAL. Those are UNCTRAL terms right there. U.S. courts are also likely to encounter suits involving the expropriation of property. Not the appropriation of property, but expropriation. That's where they take your private property against what they just said here, may nonetheless be insulated from execution of resulting judgment. But they're not considering you foreign. They're using, because you're foreign, but you're using a United States instrumentality to profess everything. That's your doing. U.S. courts are also likely to encounter suits involving the expropriation of property in a foreign country, torts committed in the United States, such as automobile accidents and slip and fall injuries, enforcement of foreign arbitral awards. Remember the arbitrage? Arbitrage is something that's put into two markets for two different sales, two different market prices. And we're going to bring it all above the table and have them use his chips and double them all up. All in, all in, all in, all in, all in. I'm not going to stop saying all in, all in. You have to put in your all. That's what I'm doing. I'm putting in all my all. You do not want to be my friend. And death or injury resulting from acts of state-sponsored terrorism. The exceptions governing these situations, along with waivers of immunity, are discussed in some detail in the following sections. I thought I was giving 3 examples. It didn't. Okay. Historically, like most nations, the United States accorded foreign states and governments absolute immunity from suit in domestic court. In 1952, however, the Department of State adopted, so it didn't change anything. They accorded foreign states and governments absolute immunity from suit in domestic court. The Department of State adopted the restrictive theory of sovereign immunity in the so-called Tate Letter, reflecting its view that customary international law had evolved to permit adjudication of disputes arising from a state's commercial activities while preserving immunity for sovereign or public acts. And this is why I say, correlating with that indemnification again. That's a customary bond. That's an international custom bond where you get to use that number in lieu of a name and address. You even get to use that number in a special deposit to assign another number to it so that you can have a direct routing with another number assigned to the guy holding it. Twenty-four years later, the FSIA codified and expanded upon the restrictive approach toward immunity, adding several other exceptions. Since then, the FSIA has provided the sole basis for obtaining jurisdiction over a foreign state in our courts. Again, it is not these administrative courts, folks. It is the FSIA. And every court, they're subject to it. That's supposed to take it straight to the international court because of its foreign element. And it's evidence, the record itself is evidence that you are in fact a foreign element to that estate that they created. That being born in the United States, that resident, that United States citizen known as the United States business. Had I known all of this, I'd have never undertaken it. I'd have first educated myself, as you see I'm doing on my own now. I'm not doing this for money. I'm not doing this so I can go out and get a job and make money. Woe ye lawyers, suckers. You spent all that money and I'm going to tear you up. I'm going to shove an indemnification bond down your throat and you're going to be out of job because you were incompetent. Again, seeking counsel with an English major. You and your legalese is done. Go ahead.
And they can't practice law either, Keith.
No. Yeah, you can't practice law. Not at my expense. You can buy a portion of the suit as we speak of. You want to buy a portion of it? Even placing them in that capacity lets them understand you know a little bit more than what they might think. Because now you're making a contract with them. And they damn well better uphold to their expertise. Otherwise, it's ineffective assistance of counsel. Oops. Don't play with me anymore, people. As the U.S. Supreme Court has observed, the statute supplies a comprehensive set of legal standards governing claims of immunity in every civil action against the foreign state. As the U.S. Supreme Court has observed, the statute supplies a comprehensive set of legal standards governing claims of immunity in every civil action against the foreign state. I find that inconsistent and in controversy with the statement we just read not too long ago. The FSIA governs all litigation in both state and federal courts against foreign states and governments. See, there's a controversy right in here. I'm going to help them out. It has sometimes been suggested that the courts initially considered the acceptance of foreign sovereign immunity to be only a matter of grace and comity, rather than a restriction imposed by the Constitution or a reflection of customary international law. You're going to recognize it as customary international law now. That particular phrase is nowhere to be found, however, in Chief Justice Marshall's seminal opinion, the Schooner Exchange, which by distinction refers to the usage and principles adopted by the unanimous consent of nations, what today we refer to as customary international law. Greetings, Robert. How you doing tonight, brother?
Good. How's everybody else?
Good, good. Enjoying some foreign sovereign immunities, our
Cool.
freedom of expression, and your right to know.
Good topic.
Yeah. So the next thing I got, this is from U.S. Citizenship and Immigration Services. And guess what they talk about?
Tell us.
Exceptions and accommodations. There are exceptions and modifications to the nationalization requirements that are available to those who qualify. English language exemptions. Telling you.
A form invoked.
I'm sorry, I failed, even though that report card says that I understood. Maybe I'm stupid, maybe I'm an idiot or whatever. I forgot some certain things or whatever, but I'm incompetent at the moment of English language. I mean, I can speak it okay, it seems, but I need to go back and learn the conciseness of it. So I require a leave of court as a foreign sovereign, immune to this language that you use here, because I'm incompetent of it. That's an easy one for most people. But it says you are exempt from the English language requirement, but are still required to take the civics test. I want to know where the requirement for a civics test is. See a problem? Do you guys ever take a civics test?
Yeah, civics is dropped now. They don't teach civics really in school anymore.
Yeah, so where's my civics test that qualified me? Under a requirement, they're saying I have to have a civics test to even have this apply. Remember, this is executive order or statute, right?
But you're foreign to it.
I'm foreign to it. This does not apply. I am not required to take a civics test. And because I didn't take a civics test, guess what? I'm not even competent of the civics.
Well, you know, and Keith, in some of these community colleges, I attended several of them, and I remember there was a few that did require a civics test before moving on to a higher level of education or writing skills. I remember that. Just
No, but not
concurrently.
everybody's subject to it, and certainly not everybody's required. Because if it was, it'd be one of the primary factors in school. See the problem?
Sister's terminology was square on though. In
Yeah.
writing, it's in writing also.
Yeah,
So
I'm not competent
you
with the
advance
writing.
as your writing gets trickier.
Yep.
Your wording gets trickier, I guess is a word we could use.
Well, yeah,
Yeah.
as the reading level goes up, you have to have the comprehension of that reading level. You know, there's upwards of 26, 27 reading levels.
And Keith, one thing I remembered, if you did the civics test and you did poorly on it, they gave you a remedial course in order to bring up your writing skills.
Yep.
That's why we're not part of those, right? Correct?
Yeah, because we're not required. You show me one requirement anywhere.
There's none.
It says here,
we create.
You're exempt from the English language requirement if you're age 50 or older at the time of filing for naturalization and have lived as a permanent resident, in the United States for 20 years. Age 55 or older at the time of filing for naturalization and have lived as a permanent resident in the United States. I want to know where I'm required to file for naturalization. I was born naturally already. That is naturalization. So show me the requirement for filing. You can't. And if you could, I guarantee you, it doesn't apply to me because it's going to be in statute form or executive order form. That's not my form. Even if you qualify for the 50-20 or 50-15 English language exceptions listed above, you must still take the civics test. I'm not competent of the civics test. Why? It has nothing to do with my age. It has to do with the language.
They're trying to come in that back door. That's funny.
You will be permitted to take the civics test in your native language. What's the native language? There ain't none.
One we create. I create.
Everything's fiction. When it comes to this written language, or our comments as this English language is concerned, etymologically it says our comments are inventions, fabrications, and fiction. That's why I say you have to coin your words or purse your lips, because if you don't, nothing valuable is going to come of them, and in fact, you might harm yourself. You have to be careful to maintain good works and good words.
They're trying to control right there in that thing. They're trying to maintain control.
Yep.
Of the living person, of us.
Absolutely. Yeah. If you take, that's why we're born on a spell of illness, so we can learn how to spell. Try to get out of that curse. And the more we learn how to spell without knowing why, the deeper we get compelled or impelled into that curse. If you take the test in your native language, you must bring an interpreter with you to your interview. So again, you got to show me where you have the authority to qualify that I'm required to have a naturalization if I'm foreign. What am I foreign to? See, that's the base foundation. Foreign what? Most people think it's because they're coming to the United States and they're foreign to the United States. I'll remind you, the United States is located in Washington, D.C. So when I have some foreigner from Zimbabwe talking about how smart he is because now he's a United States citizen taking advantage of the American dream, and I said, well, where do you live? He says, in Florida. I said, so you've never been in the United States, huh? Well, no, I live in the United States. I thought you just said you lived in Florida. And now he's getting flustered already. You better understand the English language and what they're saying. You can't be both in the United States and in Florida, particularly when you're not in it. You're on the land, and somewhere they've got a magical border that says Florida. Your interpreter must be fluent in both English and your native language. So how about I just bring that interpreter, the English major, to help them help you understand your babble. Very succinct language. If you are age 65 or older and have been a permanent resident for at least 20 years at the time of filing, again, resident. So again, it doesn't apply. I've never been a resident. That's always been an assumption and presumption, an implication, falsely judged. Because that fucker on that bench knows he doesn't have authority over the estate of a person who is in fact alive.
You don't even know how damn old you are, Keith.
I don't. I don't.
I know I don't.
So let's take a look at the last one I got here. And this is just the tab that I opened up when I searched United States citizenship exemptions. So it says there are exceptions and modifications to the naturalization requirements that are available to those who qualify. So there are naturalization requirements that are available to those who qualify. So it sounds like it's not required until you qualify. Because if you don't qualify, then you can't be naturalized as a requirement. Do you see the babble? First one says, what are the exemptions for the citizenship test? Those who have been living, what we just read. Those are the exemptions. What disqualifies you from U.S. citizenship? You have been convicted or admitted to a crime involving moral imperfectude or moral turpitude, such as fraud. You spent 180 days or more in jail or prison for any crime. You committed any crime related to illegal drugs other than a single offense involving 30 grams or less of marijuana. This is the waiver. What is the 5515 exception for naturalization? And that's a waiver.
No waiver.
What are the exceptions to birthright citizenship? In multiple cases decided in the late 19th and 20th century, the Supreme Court has recognized that only 3 narrow exceptions to birthright citizenship. Diplomatic children. Children of something foreign. I'm a child of God. I live in this world, but I'm not of this world. I am not in your nation. I am a prophet unto the nations, so sanctified and ordained. Tribal Indians and invading armies. Is there a waiver for citizenship? For example, if you are requesting a fee waiver, why do they see? They don't want to tell you that there's a waiver for citizenship. If you're asking for a fee waiver, application for naturalization, you must pay da 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 da. See, they don't want to tell you that there's no waiver of citizenship because the citizenship is an application. Can a person with a criminal record become a United States citizen? In other words, can they become a business? While an arrest or crime for which you were not arrested will not result in automatic bar, whether temporary or permanent, it can result in the denial of your naturalization application based on lack of moral character. So I want to ask you, if you haven't even developed a moral character, then why would they be putting a naturalization on you? You know, at birth. Would that itself be either unconscionable or moral turpitude? I mean, I'm only asking.
It depends. If you haven't formed that as of yet, yeah. Haven't formed it yet, boys.
So how can you determine that? How can you determine that an infant has any morals at all?
Yeah.
So if that's the foundation,
right?
If that's one of the foundations of naturalization is your moral aptitude, then how do you discern that upon enumeration at birth? See, they have certain things that make it an inauthentic claim. Just by their own language here. Let's see here. It says, what is the new law for naturalization? The bill establishes a roadmap. This is Act of 2023 for undocumented non-citizens by allowing them to apply for temporary legal status.
Not lawful.
Temporary legal status. What do you think the permanent residence is? That's a permanent legal status. You're still applying for a temporary legal status. He's no respecter of persons. You don't need a legal status. They are at law and you are in law. You live in this world but are not of this world. The tables have been flipped already. You just have to see how they've been flipped. And with that, we come to the end of the stream again for tonight. What do you guys think? Any errors? Anything I missed? Anything you want to bring up?
The coming in and going out, basically.
Yeah.
Yeah, absolutely. That's exactly what it is. Before I formed thee in the belly.
And we're creators, so we need to create our own documents, and that's what's so important for everybody to remember. You're recording. The book's frazzled. We are recording with our truth and our documents.
Yep.
Yours, mine, theirs, in trust.
Yep, and that's your right to private journal, like I said.
Yeah. Nobody's business. And when we create wealth. Or what deforms wealth or defines it, or
absolutely. Yeah. And it's just a matter, again, you know, I do a lot of this research on all these codes and everything, and all I'm doing here now is just showing you how the dots connect for me, because each of these different codes and stuff, they use similar language, and when you learn that language and you're able to see it, now you're going to be able to hopefully break it down for yourself and comprehend it. That judge looked at me that day and said, "Do you understand English?" And I thought in all my life, with all the times I'd walked around with dictionaries in my backpack, dictionaries, that damn right I know the English language. The problem is I didn't understand it. And I don't to this day. I do comprehend it much better. And it's through the research and seeing how it's used in all these different forums that when you start picking up on the very simple terms that they're using, you learn to stay away from the big words. And you start learning how to express the simple trust and the simple contract.
Per your word, and it's put that in your trust.
Yep.
That little thing right there, just add it to it. So
Yeah.
yeah, it's easy. But you were talking about these codes are so important because the answers in the simple words, it seems, break up the words, break them up.
Yeah, this is all intellectual property that's now part of my trust. These videos will go into my trust property, my little
Your recording.
my little journal. You know, this is my journal.
Yep.
So we get to use this stuff to our advantage, and I urge people to start learning how to use this. And again, get back to that concise English. Understand what's being done is the confusion of the words, and when you can see that they're using the same basic terms when they talk about principal and agent and obligee and obligation and obligor and third party and real party and interest and all that. It's all contract and trust law, and you can use it to show them what part of that contract applies to you and how. You're the third party.
Well, see,
The
Keith,
overrider.
in a lot of these state schools, or what you call I guess secondary colleges before you go to universities, what they call this remedial thing is called Common Core. So if you understand Common Core very well, you can move through their system effectively and efficiently.
Absolutely. And that's why I say we've got to start learning how to rightly divide the word of truth. And with that, we are out. What do you guys got?
Create your own
Just,
contracts.
just glance at what I have in the background, Keith. But other than that, all praises to the Most High, and I'm good.
Absolutely. Thank you.
Good show, Keith.
Address.
Thank you, John.
Need
All
an
right.
address.
Oh,
Whenever you get
Iman, can you drop your email in the back chat? My apologies. I am so bad at that,
I
Robert.
don't know how to do back text. Check out your text messages.
Yeah, she's going to drop it in the back for me, and then I'll email it to you.
I sent you a solar. You're gonna have to blow it up on your phone, but the salt chart. So it's for the months. It'll show you what you need and what you were missing and all that. It's a little chart.
Okay.
So it's in your text message on your phone.
All right.
All right,
And
brother.
I
Thank
am
you.
going. You bet. And I'm going to go ahead and drop her email to you here. Let me get it. I thought I had it. You'll have to.
I think she dropped it in, Keith.
Yeah, she did, but I don't see Robert. I don't see your email in my stuff here.
On your phone, your personal phone.
No, on my laptop in WordWise Warrior. Send me.
I don't know how to do that. Shit, I don't even know how to. Yeah, good luck with that one.
All right, I'll just type it over on the phone.
Yeah,
for you in a bit.
That's easiest with me.
Right.
I apologize for that, but
all right,
yeah.
No problem.
Thank you.
All right, and with that, guys, you know me. I love you, but I don't give a rat's ass whether you love me back. And that's say I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. Bye now.